Sir, regarding the first part of the observations made by the Honorable Member arising out of the comments of Professor Gadgil, as I remember, there were 3 points. Firstly, that the Planning Commission had not developed appropriate criteria, and secondly, that it had not worked out the annual plans with appropriate breaks up. These were two things, and then there was another question about the Planning Commission mixing up with the policies of government and not giving proper advice or submitting to wrong policies, and also that the Planning Commission did not watch the progress of the plan even in its broadest elements. These are fairly grave charges. It is up to the Planning Commission to say what answer it has for these things. Regarding annual plans and breakups, sir, honorable members here are familiar with the annual plans and that the central and state governments base their annual budgets on annual plans. After a very careful examination of all aspects and after prolonged discussions between the states and the central ministries, all the material that is available is pressed into service. To that extent, Professor Gadgil's charge is not correct. About criteria, the complaint may be true because it takes experience, time, and technical tools to develop the criteria and the yardsticks. Though we have made some progress in this direction since the first plan was got ready, I do not think that we can be or should be satisfied with the progress that has been made. Regarding the other thing, the question of watching progress by the Planning Commission, even in general terms, and that it was not able to check certain gross errors and distortions that may be taking place, well, I cannot vouch for the Planning Commission having done its part in this respect adequately and correctly because I have in mind a certain aspect of the duties and responsibilities of the Planning Commission about which there cannot be complete justification. For example, on the question of foreign exchange resources. There was the question of import licenses which were issued, regarding which some honorable members said that they had been issued on a lavish scale over a certain period. It is quite true, and a statement was laid on the table of this House about these licenses and an explanation was given. Even that explanation did not deny that somebody was responsible for it. We may say that it was the responsibility of the Finance Ministry or the Commerce and Industry Ministry, but the responsibility of the Planning Commission cannot entirely be disowned. This is something which I have in my mind, but I also know hundreds of things to which the Planning Commission diligently applies itself, watches, informs and conveys its advice on many matters. It does so from day to day. What Professor Gadgil has said about the Planning Commission may be partly true but not largely so. And regarding the kind of policies, it is a debatable ground. It may be that with some policies Professor Gadgil agrees and not with certain other policies. Therefore, when the Planning Commission aligns itself with certain policies of the government or helps the government to formulate policies in a certain manner, and if those policies somehow do not coincide with the viewpoint of a particular person, for him to say that the Planning Commission has skimmed or has subordinated its judgment is not a good and correct thing. It really is throwing doubt on the integrity of the Planning Commission. Sir, the Honorable Member quoted from an article by Professor Galbraith and observed that the socialism to which this government is committed in this country is illusion. He is not a protagonist of socialism himself, and he explained those aspects, that is, we here in India have much less of regulation of the economy than is the case in countries which have no plans at all. We are unable to direct our economy even to the extent as is being done in countries which do not lay any claim to socialism. That is the main content of Professor Galbraith's article. For what purpose, he said that is not the question here. He said that in advanced countries they have tools and instruments for controlling and directing the economy on lines compatible with certain objectives. It is true that we have not got all these tools and instruments sufficiently well developed in this country. The Honorable Member Mr. Dave said that fiscal and credit regulations won't suffice for fulfilling plans of the size, magnitude, and complexity. That is perfectly true. Not that we have no instruments, we have some instruments, but as far as I can judge, they are not adequate. On the other hand, when government applies some of these instruments and tools, there are shouts from a number of people against whatever regulation we introduce and practice. Then, sir, the question of centralization was raised. It was pointed out that planning in this country is centralized and it should now be decentralized. This bill has been brought forward for the purpose of amending the 1954 Act, which originally applied to Part A state high courts, but after the reorganization has been so adapted as to make it applicable to all the high courts in the present states. Formerly, so far as the then British India was concerned, we had the Order of 1937 under the Government of India Act of 1939. That act or the order was in force as appropriately amended or adapted from time to time. Then, you are aware that the Constitution was passed, and according to the Constitution, certain rules were laid down both in the body of the Constitution itself as also in one of its schedules. So, certain conditions of service were specified as, for example, the question of the remuneration of the High Court judges and the Chief Justice in the various High Courts. But some matters remained, and therefore in 1954 an act was passed by Parliament so far as the then Part A state high courts were concerned. Before that, sir, you are aware that after the integration of states, we had under the Constitution what was known as Part B states, and there were high courts therein. So far as these high courts were concerned, an order was passed in 1953 governing the conditions of service of the Part B state high court judges. Subsequently, after the reorganization of states, you are aware, sir, that advantage was taken of the amendments to the Constitution in certain respects so far as the High Court judges were concerned, and those amendments actually came into effect from 1st November 1956. Thus, you will find, sir, that from 1st November 1956, we have the High Court Judges Act of 1954 duly adapted after reorganization. That is the main act, or as it is sometimes called the Parent Act, which is now sought to be amended in respect of certain matters. One is with regard to leave, and it is considered necessary to specify certain circumstances. The second is about the making of some of these rules applicable to additional High Court judges, because special provision was made in the Constitution by the 7th Amendment. Now, in this bill, it has been made clear that so far as these acting judges and additional judges are concerned, their service as such will be counted for the purpose of pension only if they are subsequently made permanent judges. Otherwise, for example, if no such provision was made, then their service for the purpose of pension would be counted only from the time they are made permanent. But here it has been made clear that in case they are made permanent, their previous service as an acting or additional judge will also be taken into account for the purpose of their pension. So far as leave is concerned, whatever leave they would be entitled to in view of the period of service that they have put in as acting judge or additional judge will be taken into account, and under the scheme of leave as mentioned in the Act of 1954, they would be entitled to a period or periods of leave as then laid down. Then, sir, after this is very important question arose so far as the unexpired leave was concerned, as also the question of the provisions of the former Part B State High Court judges who were continued as judges in the new High Courts that were established on the reorganization of states. We had some High Courts, as you are aware, in Part B states. When under the Constitution, these Part B states themselves ceased to be as such and they were placed in the reorganized states of India. Naturally, the High Courts in Part B states also disappeared. So far as these judges were concerned, a very large number of them were ultimately appointed as judges in the new high courts under the States Reorganization Act, and naturally a question arose as to what is to be done so far as the period of service that they had previously put in the Part B state high courts was concerned. A question arose as to whether the period of service that they had put in as a High Court judge, including in some cases as Chief Justice, should or should not be taken into account, or whether some other formula should be introduced by which a particular period and not the whole period should be taken into account. In this connection, two questions arise. One is about leave. If, for example, they were entitled to certain periods of leave and then by the time the new High Courts came into existence, they continued in effect to the High Court judges, what was to happen to the unexpired leave period?